Hello, good evening and welcome to BYJU'S Exam Prep. Beginning today, join me live every Saturday 8 p.m. onwards and let's discuss important news articles, editorials, columns, topics and issues from the world of polity relevant for the civil services examination. Today is episode 1 of Polity This Week, and I promise this weekly initiative is going to be extremely useful and helpful for your exam. Should you also find this initiative helpful, please press the like button, subscribe to our channel if you haven't yet, drop in your comments and let us know, and share the links of these sessions with your friends and fellow aspirants. These are the topics that we shall be discussing today, covering sources such as the Hindu, the Indian Express, Hindustan Times, the Wire. We'll be discussing a couple of MCQs for your prelims examination. I'll also give you an assignment for mains exam. And then there is something called Watch Out. And for that, you will have to watch the entire video. Let's get started and look at topic number 1, Governor versus Government, written by Mr. Faizan Mustafa in the Indian Express. But listen to me carefully. We'll discuss this column, but on this particular issue, the governor versus the government, series of articles have been published in various newspapers and websites. We will cover all these sources apart from this column so that on this topic you don't have to search anything extra. This topic would be complete. Similarly, all the topics that we shall be discussing today, my endeavor would be that if you attend this video in its entirety on these topics, you will have to search nothing else. This is going to be a complete revision and complete understanding for all the topics that we are discussing. Let's get started and look at Article 176 of the Constitution. Article 176 of the Constitution gives the right to the governor of a state to address the first session of the state legislature. This is the similar power which is available to the president under Article 87 of the Constitution, because the same parliamentary system that we follow at the central level, we follow at the state level as well. What does that mean? The first session of a year is addressed by the governor and the president. President in case of parliament, governor in case of the state legislature. Not just this, after a general election, when a new Lok Sabha is elected, when a new legislative assembly is elected, the governor addresses these newly elected legislative assembly members. The president addresses these newly elected Lok Sabha MPs as well. So long story short, under Article 87 of the Constitution, president has the right to address the first session of the parliament. Similarly, under Article 176 of the Constitution, the governor has the right to address the first session of the state legislature every year. The text of this speech or governor's address is provided by the cabinet. And the speech basically highlights the policies and the programs of the government. So the governor's speech, the text is provided by the cabinet, highlighting the various policies and programs and initiatives of the state government. This text is prepared by the cabinet and the governor has to read this. Not just this, after the address is over, then there is a general discussion on this address, and at the end there is something called voting. This is what we call motion of thanks. When the governor addresses the state legislature, the text is provided by the cabinet. At the end, there is a discussion on this governor's address, followed by voting, and that is what we call motion of thanks. If this motion of thanks is passed by the Legislative Assembly by simple majority, the government survives. But if this motion of thanks is defeated in the Legislative Assembly, it amounts to vote of no confidence against the Chief Minister. The Chief Minister has no other option but to resign. And this has happened in the past. For example, in 1967, the then Chief Minister of Punjab, Mr. Gurnam Singh, had to resign because this motion of thanks was defeated in the Legislative Assembly. Similarly, the then Chief Minister of Uttar Pradesh, Mr. Chandrabanu Gupta, He had to resign because this motion of thanks was defeated in the Legislative Assembly. Similarly, at the central level as well, when there is a president's address, followed by a discussion, followed by the voting on this motion of thanks, if it is defeated in Lok Sabha, that means it does not obtain simple majority in Lok Sabha, the Prime Minister has no other option but to resign because this is the defeat of the policies and the programs of the government. This defeat basically means vote of no confidence against the Council of Ministers. But to tell you, if this motion of thanks is defeated in the Rajya Sabha, does that mean the government loses the confidence? No. Why? Because parliamentary democracy means the Council of Ministers are accountable to, responsible to the lower house of the Indian Parliament, which is Lok Sabha. Which means if this motion of thanks is defeated in Rajya Sabha, it does not affect the stability of the government. But then this speech, this governor's address, there are some critical questions that we need to understand. Does the governor have the power to skip this address altogether, not address the state legislature at all? Or does the governor have the power to skip some portions of this address? Something which has happened in Tamil Nadu. The Tamil Nadu governor had to address the state legislature because it's the first session of a year. The speech was prepared by the cabinet, but then the governor skipped some portions of the speech. This speech was referring to commendable law and order situation in Tamil Nadu, which the governor skipped. This speech referred to Dravidian model of governance, which the governor skipped. The governor's speech also found mention of important leaders such as Annadurai, Periyar, Dr. Ambedkar, various other individuals, for example, K. Kamaraj, an important leader from Tamil Nadu, and the governor skipped these portions as well, these references as well. That is what led to a conflict between the chief minister and the governor. But is it for the first time that the governor is skipping some of the portions of the governor's address? No, it has happened in the past. But something unique happened in Tamil Nadu. And what is that uniqueness which happened in Tamil Nadu? I'm going to tell you, but slightly later. Previous instances, for example, in Rajasthan, the governor had to address the first session of the state legislature and the governor skipped some portions of the speech which was prepared by the cabinet. Matter went to the Rajasthan High Court. Rajasthan High Court said, if some portions of the speech have been delivered and other portions have been skipped, we can assume that the governor has completed his address, even if the governor has skipped some portions. So speaking something which is part of the governor's address, even if excluding some portions does not matter, basically the governor has completed the speech. But something happened later in West Bengal. The governor had to address the first session of the state legislature. There was pandemonium, there was ruckus, there was chaos in the state legislature. The governor is pleading before the members of the state legislature, silence, silence, please allow me to address the state legislature. But this request of the governor went unanswered and ultimately the governor did not give the speech and ultimately left the state legislature. Matter went to the court and the Calcutta High Court said something spectacular, something important. The Calcutta High Court said, it is the right of a governor, the duty of a governor, obligation on part of the governor, and it is mandatory to have the governor's address. It is necessary. But if for some reason the governor is unable to complete his address or give his address in this situation, what will happen? Because the governor of West Bengal, when she did not address the state legislature, she walked out of the state legislature. Then the Speaker of the Legislative Assembly took his seat and then made a speech and it said the governor had been pleased to address the state legislature and laid the copies of this speech before the Legislative Assembly. Which means the governor did not address the state legislature. All the speaker did, laid the copies of the speech before the state legislature. Calcutta High Court said, since it is mandatory for the governor to address the state legislature, but if for some reason he is unable to do so, then even if the speech is laid on the floor of the Legislative Assembly, it means that the governor's address is complete. But later on, in another instant, the Calcutta High Court said the governor also has a right to skip some portions of the governor's address. Because what is mentioned in this governor's address, the policies and the programs of the government, the Calcutta High Court said if there are some references in this governor's speech, in this governor's address, which are irrelevant, which are not relevant to the policies and the programs of the government, then in that case, what will happen? The governor can skip some of these portions. There is nothing irregularity here. Pandit Nehru, in the initial years of India's republic, he said that if the president's address has some content which is incorrect, which is false, which is not appropriate, the responsibility is with the government which has prepared this content. The responsibility is not with the president. Similarly, in the Constituent Assembly debates, Mr. K.T. Shah, who was the member of the Constituent Assembly, Mr. K.T. Shah gave a recommendation that Article 87 should be amended. In a sense, when the president has the right to address the session of the parliament, the president, apart from speaking whatever is prepared by the cabinet, the president should have the discretion to also include other portions in his speech, even if those portions are not prepared by the central government. That means he should have the discretion to include something else apart from the speech which is prepared by the cabinet. But Dr. B.R. Ambedkar, the architect of our constitution, rejected this amendment. And for that, we need to go back to the British conventions. Ours is a parliamentary form of democracy. And we have borrowed parliamentary form of democracy from Britain. And there are some conventions which are part of British constitutional principles. Those conventions are also part of the Indian parliamentary system as well. And there is a well-established principle, convention in Britain. Since 1829, the king or the queen is giving a speech addressing the parliament and including in her speech only those provisions which are mentioned by the cabinet. That means whatever speech is prepared by the cabinet, the king and the queen will have to speak only those lines and not deviate from the speech prepared by the cabinet. British constitutional expert Ivor Jennings, he also said something spectacular. He said the king or the queen may suggest some changes, may suggest some modifications, may suggest some alterations. But once the speech is prepared by the cabinet, the king or the queen should only read those portions prepared by the cabinet. And this is where we can link it with another concept known as the constitutional morality. What is constitutional morality? Adherence to that written text of the Constitution. But not just adhering to the written text of the Constitution, adhering to the established conventions as well. So constitutional morality should have dictated the governor of Tamil Nadu that you should have completed the speech, completed the address, not skip the portions because the text is prepared by the cabinet and ultimate responsibility is that of the cabinet. But something unique, as I said at the start, happened in Tamil Nadu. And what happened? Previously also, this is not the first instance when the governor is skipping some of the portions of the governor's address prepared by the cabinet. But previously, the chief ministers, the government would take it lightly. But this time, when the governor of Tamil Nadu skipped some of these portions mentioned in the governor's address, the chief minister of Tamil Nadu, Mr. Stalin, got up and introduced a resolution in the legislature. And the resolution said that we will record only those provisions, only those parts which are mentioned in the governor's address. Because in parliament, in legislature, whatever is spoken is recorded, is kept in record. And the Tamil Nadu Chief Minister's resolution was that we will record the speech, the text which is prepared by us. That means we will record even those provisions which have been skipped by the Tamil Nadu governor. Mr. Stalin was speaking in Tamil. The governor did not understand this, but when he realized what the Tamil Nadu's Chief Minister is saying. He got up and left the state legislature. And that is what Mr. Faizan Mustafa says and writes. Tamil Nadu incident is a pointer to a growing trust deficit between the office of the governor and the opposition chief ministers. And a beautiful line, a beautiful paragraph has also been mentioned in this article, and I will read it out for you. But from this topic, you should also look at, and you should also cover the static portion of your syllabus. Vis-a-vis, why do we need the office of governor? What was the need to have the office of governor in a federal polity? Arguments in favor of continuing with the office of governor, because there are some demands that the office of governor should be abolished. Should the office of governor be abolished, or should it continue? Or should we follow the recommendations given by the Sarkaria Commission of 1985? Or should we follow the recommendations given by M.M. Punchi Commission as well? Those are the key points that you will have to keep track of. But at the end, you can write the beautiful paragraph written by Mr. Faizan Mustafa. And what is that? The governor reigns, but does not rule. He's a constitutional head, a titular head. Ours was the idea under which the governor had a faint presence, like a full moon at noon. His primary role as a sagacious counselor is to be consulted, to warn and to encourage the government. Both governors and the chief ministers, as constitutional functionaries, should respect each other or at least have a working relationship with each other. That completes our topic 1, governor versus government, from the Indian Express. Clear? Let's look at another topic. Why the Bombay High Court order releasing Chanda Kochhar and Deepak Kochhar is significant. And for that, I will give you a brief context of what this issue is all about. This article has been taken from the online portal, thewire.in. Chanda Kochhar and her husband, Deepak Kochhar, were mentioned as accused when an FIR was filed against them in the year 2018. What was this case all about? It was basically a loan fraud case. What is the context? Ms. Chanda Kochhar, she was the managing director and the chief executive officer of the ICICI Bank. She was part of a committee which gave loan to Mr. Venugopal Doot, who was the promoter and the head of the Videocon group. The loan was amounting to 300 crores, and the investigation revealed that there was an element of fraud here. There was an element of fraud in a sense that the loan was given to Mr. Doot, flouting the rules and the norms of the ICICI Bank. And the investigation alleges, we don't know whether this is true or not, but the investigation agencies allege that there is an element of quid pro quo. In a sense, give and take. Give and take in the sense, investigation agencies allege that out of the 300 crores which was given as loan to Mr. Venugopal Doot, close to 64 crores were given to an organization or given to a company which is controlled by the husband of Ms. Chanda Kochhar, who is Mr. Deepak Kochhar. Which basically means, in exchange of the fund diversion, the loan was given to the promoter of Videocon Group, flouting the rules and the norms. Investigation agencies also allege that a 5 crore worth of property, which belonged to Mr. Venugopal Doot, was sold to the Kochhar family for about 11 lakh rupees. Basically, the investigation agencies are alleging quid pro quo, give and take. Both the husband and wife cooperated with the investigation, appeared before the investigation agencies multiple times, but they were never arrested. They were not arrested even in 2018 when the FIR was filed. But on the 23rd of December 2022, last year, when they appeared before the investigation agencies, they were arrested. They approached the trial court for bail. The bail was denied. They approached the Bombay High Court, and the Bombay High Court ordered the release of Chanda and Deepak Kochhar on bail, and that is what legal experts say is significant. Is significant, and we should celebrate this just like we celebrate the win of the Indian cricket team. Why? This is where an important question can be asked in your mains examination. Jail is an exception. Bail is the norm. Comment by citing relevant case laws. Because look at the 2022 mains paper. Now the UPSC is directly asking you, comment on a particular issue by citing relevant case laws. Legal experts are saying this granting of bail to Chanda Kochhar and Deepak Kochhar is to be celebrated because it is in line with Arnesh Kumar versus State of Bihar judgment way back in 2014. And this is the most important judgment that you have to keep note of when it comes to bail in offences. Bombay High Court in this case has reiterated an elementary practice in judicial system. If you have a right to do something, it does not justify the act of doing it. The mere fact that you have a right to do something does not justify you committing that act. And what is the significance of this? Under section 41 of Criminal Procedure Code, you don't have to remember these sections, but just understand the concept. Under sections 41 of the Criminal Procedure Code, the police has the right to arrest an individual or arrest accused for proper investigation of an offence. Under Criminal Procedure Code, the investigation agencies, the police, they have the right to arrest accused for the proper investigation of a case. What the Bombay High Court has said, just because you have the right to arrest an accused does not justify your act of arresting them unless and until you are giving significant reasons or justifications for this arrest. Why? Because that is in line with Arnesh Kumar versus State of Bihar judgment of 2014. Very briefly, what was that judgment all about? It was under section 498 capital A, which amounts to cruelty against women. This section was added to the penal code to provide some relief to a woman who may be subjected to cruelty by the husband or by her in-laws, maybe for dowry. For example, Mr. Arnesh Kumar, he applied for anticipatory bail. Why? Because he was an accused under section 498 capital A of the penal code. He applied for a bail. Why? Because his wife, she alleged that I am subjected to cruelty by my in-laws, by my husband, because they are demanding a car, they are demanding some gifts, they are demanding some property. They're basically pressurizing her for dowry. And she explained this demand to her husband, and the husband, Mr. Arnesh Kumar, is basically taking the side of his family and not taking the side of his wife. So basically it amounts to cruelty. A case was filed, and now Mr. Arnesh Kumar is seeking anticipatory bail. In this case, the court said that there is an element of misuse of section 498 capital A. Sometimes the bedridden parents of the husband have been arrested on the charges of cruelty. Sometimes those family members who have stayed abroad for multiple years, they have also been arrested on the grounds of cruelty, because this section has been, according to the court, misused, overused, abused, hyperused. And in this Arnesh Kumar judgment, the Supreme Court said jail is an exception unless and until it is absolutely necessary to arrest an individual. And for that you have to give strong, valid justification as well. And this justification should be mentioned in the arrest memo as well. Unless and until it is clearly mentioned with written justifications, why do you need to arrest an accused? You cannot arrest. And at the same time, in all these offenses, listen to me carefully, where the punishment is less than 7 years or up to 7 years, basically where offense is not a heinous offense. If you are an accused in a particular case where the punishment can be up to 7 years or less than 7 years, jail is an exception. Bail is the norm. Only in exceptional circumstances you can arrest an accused. That too after providing strong, valid, written justification for the arrest. And you can't say we are arresting somebody because of non-cooperation. Now listen to me carefully. The investigation agencies in Chanda Kochhar case, they're saying we needed to arrest these individuals because they are not cooperating with the investigation. And since they are not cooperating with the investigation, that is why we need to arrest them. This is the strong, valid justification for their arrest. The Bombay High Court said something spectacular. The Bombay High Court said non-cooperation cannot be substituted with confession. What does that mean? If Chanda Kochhar and her husband, they are not evading arrest, they are cooperating with the investigation. Whenever you call them, they appear before the investigation agencies. But if you are still saying they are not cooperating, that does not mean for you cooperation is they should confess to their crime. Just because they are not confessing to their crime, they think they are innocent, that does not mean they are not cooperating. So since the allegation against Chanda Kochhar is not heinous, the offense under which she is being arrested is not a heinous offense, there is no strong written argument justifying their arrest. And that is why the Bombay High Court ordered the release on bail of Mr. Kochhar and Ms. Chanda Kochhar. And that is what the wire.in is mentioning. The Kochhars were arrested 4 years after a case was filed against them, without any real basis recorded in writing, without any strong arguments justifying their arrest. And non-cooperation does not mean that you have to substitute it with confession. Just because an accused is not confessing to his or her crime, you can't label that accused as non-cooperative and on this ground seek arrest of these individuals. That is why on this matter, this is an important article relevant for your mains examination. The question can be, jail is an exception, bail is the norm. Justify by citing relevant case laws. And relevant case law can be the Chanda Kochhar judgment of the Bombay High Court, can be the Arnesh Kumar versus State of Bihar 2014 judgment, can also be the Arnab Goswami judgment, because the same argument was used by Mr. Goswami in his bail application as well. That's about it. That completes our topic 2. Now let's look at topic 3, a timely halt. And we have taken this topic from the Hindu newspaper editorial. What is the context? 4,000 families are residing in an area known as Gafur Basti, which is in Haldwani town. The state is Uttarakhand. The state claims that these 4,000 families have encroached upon the land which belongs to the railways. So these are encroachments, these are encroachers, they have encroached upon the land which belongs to the railways and therefore they deserve to be evicted. Matter went to the Uttarakhand High Court. The Uttarakhand High Court ordered the eviction of these 4,000 families in 1 week. The Uttarakhand High Court said, if necessary, force can also be used. If necessary, paramilitary forces can also be used. These 4,000 families then approached the Supreme Court. And on January 4, 2023, this year, the Supreme Court imposed a stay, halted the eviction of these 4,000 families. And that is what this editorial says. It is a timely halt. But the Supreme Court made two important observations. Supreme Court said, number one, and listen to me carefully, there can be no eviction without rehabilitation. The Supreme Court said there can be no eviction without rehabilitation, number one. Number two, the Supreme Court said that this time limit, which was given by Uttarakhand High Court, that you need to evict these 4,000 families from this area within 1 week. This 1 week time limit is draconian, considering the fact that these families have resided in this area for many years. And these are the two crucial observations made by the Honorable Supreme Court while staying the eviction of these 4,000 families from Ghafur Basti area of Haldwani town in the state of Uttarakhand. But to understand this news column in great detail, we need to understand the Supreme Court judgments of Kenya and South Africa, because recently these two Supreme Courts, they have given landmark verdicts on similar issue. And what these two Supreme Courts basically said, let me summarize. The Supreme Court said, what you call encroachments and who you call encroachers, it is nothing but the failure of the state to discharge its constitutional duty, constitutional obligation of providing shelter and housing to the people. Yes, these people, they may be illegally occupying a piece of land. This land may belong to the government. They may occupy this piece of land illegally. But what does that mean? Even if they are occupying this piece of land illegally, but their right to shelter, right to housing has been violated by the state because the state has failed to discharge its constitutional obligation of providing safe housing and shelter to these people. And at the same time, if they are living on this particular piece of land, they may have set up shops, they may be selling something on the pavement, so their livelihood is dependent upon this piece of land. So you are violating their right to livelihood by evicting them. But that does not justify their encroachment. You can evict them, but for that you need to first rehabilitate them. And at the same time, they have the dignity. Right to dignity is their fundamental right. So what you need to have a meaningful engagement with them. Engage with these so-called encroachers. Engage with them and give them alternate accommodation. Because if we are evicting them, but their constitutional rights of shelter, housing, livelihood is getting impaired. And for that, we need to meaningfully engage with them, give them alternate accommodation, give them rehabilitation. That's the key question that these two Supreme Court verdicts raise. And even our Honorable Supreme Court repeatedly in previous judgments have reiterated that although these encroachments does not give them the legal right to claim that land. You may be occupying a piece of land, but this land does not belong to you. You're encroaching upon this piece of land. That does not give you the legal right to claim this land. But by evicting you, we are violating your constitutional guarantee of right to livelihood, right to housing, right to shelter, which the Supreme Court previously has expanded, is a fundamental right under Article 21 of the Constitution. Because inferred right, because Article 21 talks about right to life. The state shall not deprive an individual of his right to life and personal liberty, except according to the procedure established by law. But the Supreme Court has expanded the scope of Article 21, expanded the scope of this term known as life, and has given us those rights which originally were not part of the Constitution. The Supreme Court said right to livelihood is a fundamental right. Right to shelter is a fundamental right. Right to housing is a fundamental right. Similarly, right to privacy is a fundamental right under Article 21 of the Constitution. So basically, the Supreme Court, in its order on this Haldwani town area dispute, is basically saying that there can be no eviction without rehabilitation, and at the same time, there has to be meaningful engagement with these people. There are critics who say it will incentivize people to encroach upon the public land. I see a public land, I will encroach upon this public land. I know that I cannot lay my legal claim on this piece of land, but I know Supreme Court has said there can be no eviction without rehabilitation. So I can encroach upon a public land with this intention that tomorrow I cannot be evicted without being rehabilitated by the government. Which basically means this judgment of the court will incentivize people to encroach upon the public area, because they know if they cannot claim right over this piece of land, but they can claim rehabilitation. But there are others who say, if there is a mall constructed here by a wealthy businessman, and next to that mall, there is a piece of land which belongs to the state, which is a public land. This owner of this mall is encroaching into this area out of greed. But those people who belong to marginalized sections of the society, weaker sections of the society, disadvantaged sections of the society, they encroach over a piece of land, not out of greed, but because they have nowhere to go. Because the state has failed in discharging its constitutional duty of providing shelter and accommodation to these people. And that is what the Hindu editorial says. The Supreme Court, it's a timely halt on the eviction, and at the same time the Supreme Court must lay down rehabilitation norms for eviction from public spaces. Question can be in your mains exam. Does the Constitution give a fundamental right to shelter for the citizens of India? Comment in light of the recent Supreme Court verdict. 250 marks, 250 words, 15 marks, that can be the question that you can expect from this topic. A timely halt. Clear? How many students are here right now? Close to 893. If you're liking this initiative, then press the like button. Press it and let me know what you get out of pressing the like button. Okay. Building a pact on free speech. What is the context? A politician who was a minister, Mr. Azam Khan. There was an incident, a horrific incident of rape in the Bulandshahr area of Uttar Pradesh. Mr. Azam Khan, who was the minister, he said that this allegation of rape is a political conspiracy to destabilize the elected government headed by Mr. Akhilesh Yadav. Matter went to the court. The court is asking Mr. Azam Khan to give an apology. And Mr. Azam Khan gave an unconditional apology. But Supreme Court said no, the matter raises a larger issue. Are these politicians and the ministers, whatever they say, can we say that they are speaking from their personal perspective, out of their personal experience? Or can their speeches be attributed to the state? Similar speeches, comments were made by Minister Mr. Mani in Kerala as well, who was a minister under the Kerala government. But long story short, we have fundamental rights mentioned under Part 3 of the Constitution. And all these fundamental rights are enforceable against the state. The state shall not deny equality. The state shall not discriminate. The state shall not deprive an individual of his right to life and personal liberty. The state shall not do this, the state shall not do that, which means if the state is violating your fundamental rights, you can sue the state, you can drag the state to the court by issuing various writ jurisdictions. But here is a minister or a politician. He is giving a speech, maybe a hate speech as well. Can a speech made by a minister, can we assume that the speech is made in his personal capacity? Or can we attribute this speech to the government as well? If we attribute this speech to the government, government is a state under Article 13 of the under Article 12 of the Constitution, which means basis the speech given by the minister, you can drag the government to the court. That's question number one, because the court said, can we attribute the speech given by an individual minister or by a politician who belongs to the ruling party? Can we attribute the speech to the government, which is a state under Article 12, against whom you can claim your fundamental right? So basically a minister saying something, can it be said that based on the collective responsibility, this is the speech given by the government? What is collective responsibility? Council of Ministers swim and sink together. For example, if a vote of censure is passed against an individual minister in Lok Sabha, it can be assumed that we have censured the entire Council of Ministers. Because Council of Ministers, based on collective responsibility, they swim and sink together. A vote of censure against one minister means vote of censure against the entire Council of Ministers. So if an individual minister has given a speech, can we attribute this speech vicariously? Can we attribute this speech to that of the government? That's question number one. Question number two, the Supreme Court, a 5-judge constitution bench of the Supreme Court had to hear, should there be extra curbs or extra restrictions other than those prescribed under Article 19, Clause 2 of the Constitution? What does that mean? Article 19(1)(a), freedom of speech and expression. But this fundamental right is not absolute. Reasonable restrictions can be imposed on your freedom of speech and expression. And there are 8 reasonable restrictions imposed on your freedom of speech and expression by the Constitution itself under Article 19, Clause 2. What are these 8 reasonable restrictions? In the interest of the sovereignty and integrity of India, there can be restriction on your freedom of speech and expression. In the interest of the security of the state, in the interest of the friendly relations with the foreign states, public order, contempt of court, defamation, morality or decency, incitement to an offense. On 8 grounds, reasonable restrictions can be imposed on your freedom of speech and expression. But the question before the Constitution bench of the Supreme Court was, apart from these 8 restrictions imposed under Article 19, Clause 2, should there be extra curbs, extra restrictions on a minister, on a politician's freedom of speech and expression? These were the 2 key issues to be decided by the Constitution bench of the Supreme Court. And Supreme Court basically ruled 3 things. And listen to me carefully. By the majority of 4:1. Because one judge, Justice Nagaratna, she dissented. And this was her second dissent. She disagreed with the majority on the demonetization verdict. She said demonetization, even if the intention was clear, but the demonetization exercise was unlawful. But 4 other judges, they said demonetization is legal. Gave a legal imprint to the demonetization exercise, which was carried out on November 8, 2016. But be that as it may, the second dissent by Justice Nagaratna on this freedom of speech and expression case, what is the issue? 4 judges said, number 1, we cannot invoke collective responsibility and hold the government accountable for a speech made by an individual minister or a politician. That's Ruling number 1. That means a speech given by a minister in his personal capacity cannot be attributed to the government. Argument number 1. Number 2, there are enough reasonable restrictions under the Constitution, under Article 19, Clause 2. So there is no need to impose extra curbs or extra restrictions on the freedom of speech and expression other than those mentioned under Article 19, Clause 2. The third thing, Supreme Court expanded the scope of freedom of speech and expression. Because if the state under Article 12 is violating your freedom of speech and expression, you can drag the state to the court for infringing upon your fundamental rights. Here the third thing that Supreme Court is saying, forget about state. Even non-state actors can be sued for violating freedom of speech and expression. Right to life and dignity, freedom of speech and expression. These are so important fundamental rights that you can approach the Supreme Court even if there is a non-state actor, non-state entity violating your freedom of speech and expression. But on all these three grounds, Justice Nagaratna disagreed. She said, number 1, a speech given by an individual minister can be attributed to the government if the minister is speaking on behalf of the government. If the minister's speech is connected to the affairs of the government. For example, there are riots in a particular area. The minister is giving a speech that we will control these riots. But one section of the society is instigating the rioters, which means basically you're giving a hate speech. Since this minister is saying something, but since this minister is talking about something which deals with the affairs of the state, he is speaking on behalf of the government. On this ground, you can attribute this speech to the government. So a speech given by the minister, if it reflects the position of the government of India, if it deals with the affairs of the government of India, can be attributed to the government, which means you can sue that minister. That's number 1. Number 2, Justice Nagaratna said, it is for the parliament to pass a law and impose further reasonable restrictions on politicians and ministers. Yes, apart from those restrictions mentioned under Article 19, Clause 2, if the Parliament considers it fit, additional restrictions can be imposed. Because right to dignity is getting violated when ministers and politicians, they're giving hate speeches. And through these hate speeches, they're trying to divide the society. And Justice Nagaratna disagreed with point number 3 as well, with ruling 3 as well. She said, look at our existing criminal laws. If you are giving a speech, anybody giving a speech, whether a minister or a politician, giving a speech which is trying to promote enmity amongst different sections of the society, it's a crime under Indian Penal Code. So there already exists a provision where you can sue a minister for violating Indian Penal Code. You need not to extend this freedom of speech and expression to non-state actors because the existing law automatically deals with this. And that's what Hindustan Times writes in this editorial. Hindustan Times says, it remains to be seen whether common citizens can drag the politicians and ministers to the court for violating freedom of speech and expression. But what we need a code of conduct on hate speech. Just like we have model code of conduct, where all the political parties, they have voluntarily agreed that these are the provisions that we will follow when we are campaigning in the elections, when we are carrying out election propaganda. If we can have a model code of conduct during the conduct of elections, if the political parties want, if the political parties agree, if the political parties come together, we can have a similar code of conduct on hate speech as well, so that politicians, for petty political gains, for petty electoral gains, will not resort to hate speech, because hate speech has the potential to divide our society. That's the key question that we needed to address from this editorial, Building a Pact on Free Speech, which I've taken from the Hindustan Times. I think this editorial was on January 4, 2023. But it's very significant, that's why I've taken it this week. Then something else. The last column that we are discussing now, after that we will discuss a couple of MCQs. Then I will give you an assignment. And then, as I promise, there is something called watch out. And what is that watch out? We'll discuss later. There is a tussle between the executive and the judiciary. And particularly the tussle is on judicial appointments. You would know that India is perhaps the only country in the world where judges are appointed by themselves through a system known as collegium system. Initially, the Law and Justice Minister, Mr. Kiran Rijiju, made a statement in a television program basically criticizing the collegium system of judicial appointments. Then came the newly elected Vice President of India, who is also the ex officio chairperson of the Rajya Sabha. He used the first opportunity when he interacted, when he responded, when he spoke in the Rajya Sabha, he used the first opportunity to criticize the collegium system and basically criticized the judiciary's striking down of NJAC, National Judicial Appointments Commission. Because you would know that initially the Chief Justice and the judges of the Supreme Court and High Court were appointed by the executive. Chief Justice was consulted, but it was only a mere consultation. Srimati Indira Gandhi was the Prime Minister. She gave a slogan of committed bureaucracy, committed judiciary as well. That the judges of the Supreme Court and High Court should be committed to the ideology of the political party in power. And through this process of appointment, Srimati Indira Gandhi violated some established conventions. 24th April 1973, 13 judges of the Supreme Court had to decide and answer one key question. Is the power of the Parliament supreme that it can amend any provision of the Constitution? Can the Parliament use Article 368 to amend any provision of the Constitution? 7:6 majority. The Supreme Court said there is a limitation on the power of the Parliament to amend the Constitution. Parliament can amend the Constitution, use Article 368 to amend the Constitution, but cannot dare touch, dare destroy basic structure. So basic structure doctrine was innovated by the Supreme Court in 1973. And now the Vice President of India is not only criticizing the collegium system of judicial appointments, he is criticizing this doctrine of basic structure as well, saying it does not exist anywhere in the world. In 2014, when the Parliament enacted NJAC, National Judicial Appointments Commission, to replace the collegium system, a year later, in 2015, by a majority of 4:1, 5 judges of the Supreme Court heard this matter, heard the challenge to NJAC. 4 judges of the Supreme Court said NJAC is unconstitutional because it violates basic structure. One basic structure is independence of judiciary. Another basic structure is primacy of Chief Justice of India in judicial appointments. Because the structure of NJAC is such that Chief Justice and the judiciary will not have the primacy. Primacy in the sense will not have the preeminent role in appointing the judges. Because in NJAC, there will be the Chief Justice, 2 senior judges of the Supreme Court, but then there will be a law minister as well. And there will be 2 eminent persons as well. So these 2 eminent persons and the law minister may collude with each other to stop any recommendation of the judiciary. So it violates the role of judiciary, the primacy of judiciary in judicial appointments, which is part of the basic structure. It violates independence of judiciary as well. And the Vice President of India is saying that this practice does not exist anywhere in the world, where the sovereign will of the people, through their elected representatives in Parliament, passed a law, and now it has been struck down by the judiciary. He says that such a system does not exist anywhere in the world, where 2 chambers of the Parliament, Lok Sabha and Rajya Sabha, they passed a law signed by the President of India, supported by the majority of the state legislatures as well. But there is a 3rd chamber, judiciary, which has now struck down that law. Such a system does not exist, according to the Vice President. And the Indian Express in this editorial says, with due respect, Vice President of India, if you are criticizing basic structure, you are basically echoing Srimati Indira Gandhi's slogan of committed judiciary. Because it is the basic structure doctrine which has helped independence of judiciary, which has helped preserve the democracy in India. And for that, we need to understand 2 things. Number 1, any law which is passed by the Parliament has to fulfill 2 key requirements. Number 1, it should not violate fundamental right. Why? Because that's a restriction imposed under Article 13 of the Constitution. More specifically, Article 13, Clause 2. The state cannot pass any law to modify, abridge, delete a fundamental right. So any law which is passed by the Parliament can be challenged in the court of law if it violates fundamental rights. And second, this law can be challenged if it violates the doctrine of basic structure. So when a law known as NJAC was passed by the Parliament in 2014, it should not have destroyed basic structure, violated basic structure. And that is why the Supreme Court struck it down. But we need to understand that it is this basic structure doctrine which preserved India's democracy. For that, we need to understand what happened when Srimati Gandhi gave the slogan of committed judiciary. Now, bear with me for a couple of minutes. I'll give you something interesting. 13 judges of the Supreme Court in Keshavananda Bharati verdict had to decide whether power of the Parliament is supreme, that it can amend any provision of the Constitution. Justice Sikri was the Chief Justice of India. That his term was about to get over. His term was over. A new Chief Justice was to be appointed. The convention, an unwritten rule at that time was, whoever is the senior most judge of the Supreme Court should be appointed the Chief Justice of India. After Justice Sikri's retirement, there were 3 senior judges of the Supreme Court who were superseded to accommodate Justice A.N. Ray, and Justice A.N. Ray, who was at serial number 4 in the list of seniority, he was appointed as the Chief Justice of India, committed judiciary. Because Justice Ray, according to them, is committed to the ideology of the ruling political party. Number 1. Number 2, in 1976, one of the black spots on India's judiciary, particularly the Supreme Court. The Supreme Court was hearing a case known as the habeas corpus case, or known as ADM Jabalpur versus Shivakant Shukla case. The question before the court was, can habeas corpus be suspended during national emergency? Do the people have the right to approach the court and file a petition of habeas corpus when emergency is imposed? 4 judges of the Supreme Court said, since Parliament has passed a law, habeas corpus is suspended during emergency. just one judge dissented. Justice Khanna. Justice Khanna was then in line to become the next Chief Justice of India because he was the senior most judge of the Supreme Court. He was superseded. Justice Beg was appointed as the Chief Justice of India. So when we had a situation where executive had the ultimate control over judicial appointments, we saw committed men, women being appointed to the judiciary. And that is why Supreme Court in 1993 in second judge's case, then in 1998 in third judge's case, then in 2015 in fourth judge's case known as the NJAC case, the Supreme Court said enough is enough. We will appoint judges ourselves through this process known as collegium. But then what about the doctrine of basic structure? To understand this, we need to understand what happened during emergency. 39th and 41st Amendment were made to the Constitution. And for that, you need to understand a bit of history. Srimati Gandhi contested election from a Raebareli constituency in Uttar Pradesh. Her opponent was Mr. Raj Narayan. Raj Narayan lost the election. Srimati Gandhi won the election. She became the member of Lok Sabha from Raebareli and became the Prime Minister of India. Matter went to the court. Raj Narayan alleged that Srimati Gandhi should be disqualified on the grounds of electoral malpractice. Why? Because she has violated the Representation of the People Act. She has basically used the government officers, government machinery for election campaigning, which is an electoral malpractice, and therefore Srimati Gandhi should be disqualified. Allahabad High Court said, Mr. Raj Narayan, you are right. Srimati Indira Gandhi, you are disqualified on the grounds of electoral malpractice. Srimati Gandhi approached the Supreme Court. Supreme Court imposed a stay. But Supreme Court said, Mrs. Gandhi, you can continue as the Prime Minister, but you can't vote in Lok Sabha. So for the first time in the history of independent India, a sitting Prime Minister was disqualified by Allahabad High Court or any court in this country. And a sitting Prime Minister was not allowed to vote in Lok Sabha. And some people allege that this judgment in the Raj Narayan case became the basis on the basis of which Srimati Gandhi imposed emergency in June 1975. When emergency was imposed, two important amendments or two notorious amendments were made to the Constitution. 39th Amendment and 41st Amendment. 39th Amendment said, no case can be filed against President, against Speaker, against Vice President, against the Prime Minister on the grounds of electoral malpractice. 39th Amendment basically said the courts have no jurisdiction, no right, no control to hear a case against the election of the President, Vice President, Speaker, Prime Minister on the grounds of electoral malpractice. And 41st Amendment basically said no case can be filed, neither a civil case nor a criminal case, against the President, against the Vice President, against the Prime Minister, against the Governor, even after they demit the office. So if I am a governor holding an office for a particular day, I enjoy complete immunity throughout my life, whether in office or after I demit the office, after my resignation or after my removal or after my term is over. No civil case, no criminal case can be filed against me. If there was no restriction on the power of the Parliament to amend the Constitution, both these amendments would have been valid. Thanks to the doctrine of basic structure, when these two amendments were challenged in the Supreme Court said this violates basic structure, which is rule of law. This violates basic structure, which is free and fair election. So since rule of law is part of the basic structure, free and fair election is part of the basic structure, 39th and 41st Amendment, these are unconstitutional. That's what Indian Express editorial says. With due respect, Mr. Vice President, your criticism of basic structure is echoing Indira Gandhi's slogan of committed judiciary. Your criticism of NJAC judgment, your criticism of collegium system, basically you want a similar committed judiciary as was espoused by Shrimati Indira Gandhi. That's what you need to understand from this editorial in the Indian Express. With due respect, Mr. Vice President of India. These were the 5 topics, important topics that we had to discuss in today's analysis, Polity this week. I hope these 5 topics were interesting. Interesting alone does not matter. I hope these 5 topics were understood by you, because these are very important and crucial for your examination. Now let's look at some of the important MCQs that I've drafted, which will help you in your prelims examination. Number 1, and you can drop in your comments, let me know what is the answer. Consider the following statements regarding Section 6A of the Citizenship Act. It was introduced into the Act on the basis of the Assam Accord of 1985. Assam is the only state of India to have an exclusive cut-off date for citizenship. And third, it explicitly provides for a mechanism to protect, preserve and promote the cultural, social, linguistic identity and heritage of the Assamese people. Which of the above statements are correct? Only one is correct, 2 statements correct, 3 statements are correct, none of the statements are correct. But what is the context? A constitution bench of the Supreme Court, a 5-judge bench of the Supreme Court is hearing a challenge against Section 6A of the Citizenship Act. Assam has had a history of protests against what they call illegal migration. There was a massive revolution or a movement from 1979 to 1985, which was led by All Assam Students Union, various organizations in Assam. They basically wanted all the illegal migrants into Assam should be identified, arrested and deported. Because this illegal migration, according to Assamese, it affects the demography, it affects the culture, the language of the indigenous Assamese population. And ultimately this Assam agitation, as it was called, it came to an end in 1985 when Assam Accord was signed between the central government, Mr. Rajiv Gandhi was the Prime Minister, between the state government and the representatives of the Assam agitation, led by All Assam Students Union. There are 2 critical arguments, 2 critical things that you need to understand from Assam Accord. Number 1, whoever has entered Assam before 1st Jan 1966, they are all citizens of India. Problem solved. Whoever has entered Assam between 1st of January 1966 to 24th March 1971, they are also Assamese citizens, they are also Indian citizens, but for 10 years they will not have political rights. For 10 years they will not have right to vote, they cannot contest elections. But whoever has entered Assam on or after 25th March 1971, those are illegal migrants. Those need to be identified, arrested and deported. And that is why NRC exercise, whose results were declared in 2019, was carried out, conducted in Assam to implement this Assam Accord. Why 25th March? Because you would remember 1971, there was a war between India and Pakistan, which led to the emergence of Bangladesh as an independent entity. Bangladesh then was East Pakistan, which was under horrific and horrible oppression by the Pakistan army. And on 25th March 1971, Operation Searchlight was launched by the Pakistani army, under which horrific human rights violations were committed. And fearing that Operation Searchlight, launched by Pakistani army, millions of migrants from East Pakistan migrated into India and migrated into Assam as well. But Assam Accord, which was signed, it said whoever has entered Assam on or after 25th March 1971 should be identified, arrested and deported. But one more aspect of Assam Accord was Clause 6, which said that the government should identify indigenous Assamese and have constitutional safeguards, legislative safeguards for their cultural protection, for their identical protection, for their linguistic protection. The challenge before the court now is, because the court is hearing this matter, can there be different cut-off date for citizenship for those in Assam and for the rest of the country? Because for the rest of the country, the cut-off is July 19, 1948. Whoever has entered India before July 19, 1948, they are the citizens of India. Can there be cut-off, one cut-off date for the rest of the country and another cut-off date, 1st Jan 1966 or 24th March 1971 for Assam? That's the key question before the court. Which means statement 1 is correct. Section 6A of Citizenship Act, it was introduced on the basis of the Assam Accord of 1985. Statement 2 is also correct. Assam is the only state in India to have an exclusive cut-off date for citizenship. But statement 3 is incorrect. This section 6A does not explicitly provide for mechanism to protect, preserve culture, language of Assamese people. That is provided by Clause 6 of Assam Accord, not the Citizenship Act. So mechanism for preserving, protecting the linguistic identity, the cultural identity of the indigenous Assam people, that is provided explicitly by the Clause 6 of the Assam Accord, not Section 6A of the Citizenship Act. So only 2 statements are correct. B is the right answer. Let's look at another question. Consider the following statements. Indian Constitution explicitly provides a power to the Supreme Court to review its own judgments. The power of the Supreme Court to hear a curative petition flows from Article 142 of the Constitution. Why is this question asked? Look at this newspaper article. We won't pay a farthing more, says Union Carbide. 1984 rather, Bhopal gas tragedy. Union Carbide, from this factory, poisonous gas got leaked. Which was that gas? Toxic methyl isocyanate, which led to the destruction of a lot of people, destruction of property of a lot of people. And at that time, Union Carbide gave compensation to the tune of 715 crore in 1989. Now what the central government has done, it has filed a curative petition, basically asking the Supreme Court that we need to revisit this compensation. We need more compensation from Union Carbide by invoking curative petition, by filing curative petition. The lawyer representing Union Carbide, Mr. Harish Salve, says we won't pay a farthing more. The Supreme Court is also questioning the central government, saying, is this any way that you want to go back on your compensation, which was agreed between the central government and the Union Carbide in the 1980s, by filing a curative petition again? So on curative petition, you can expect a question. Consider the following statements. Indian Constitution explicitly provides the power to the Supreme Court to review its own judgment. Correct. That's Article 137, where the Supreme Court has the power to review its own judgment. And by filing a petition known as a review petition. Review petition should be filed within 30 days of the judgment. Review petition. But then in 2002, in a landmark case known as Hurra versus Hurra, Ashok Kumar Hurra versus Rupa Hurra, in 2002, the Supreme Court said, finality of justice is important. At one point of time, the case has to come to a halt, come to close. But this finality of justice cannot be at the cost of the justice. Which means even after review petition is dismissed, you can file another review petition. And that another review petition is known as curative petition. Curative petition is not mentioned in the Constitution, but it draws its power, scope from Article 142 of the Constitution. Because Article 142 says Supreme Court can give any order so as to provide complete justice to the people. So to provide complete justice, even after the dismissal of the review petition, another review petition can be filed, which is curative petition. And the rules say curative petition can be filed within a reasonable time limit. Which means even Supreme Court can condone delay. The Supreme Court can say even after many years you can file a curative petition if you can justify what led to the delay in filing the curative petition. But be that as it may, what is review petition, what is curative petition, you should know that. Go back to your class notes and or go back, if you're our student, go back to the tablet lectures and find out what is this review and curative petition. But both these statements are correct. C is the right answer. For your mains-based practice, there is an assignment, 2 questions. Write the answer to these questions in 250 words and share it with us. Question number 1, what is the role of a governor in India's federal polity? Do we need the office of governor? 250 words. Question 2, what do you understand by committed judiciary? Examine the role of the basic structure doctrine in upholding judicial independence. So we have covered 5 key topics, 2 MCQs for prelims, 2 mains-based questions as assignment for your mains preparation. And then I told you at the start something known as watch out. And what is this watch out? There were other polity-based articles in news in the past week as well. Watch out for those articles, but not now, when the final judgment will come from the Supreme Court. Case number 1, the Supreme Court has said a right to love is a fundamental right. Right to marry is also a fundamental right under Article 21 of the Constitution. Supreme Court in Joseph Shine case decriminalized homosexuality by saying Section 377, insofar as it criminalizes homosexuality, Section 377 is unconstitutional. So homosexuality is not a crime. Right to love is not a crime. But you cannot marry the person of the same sex in India. That is why same-sex marriages are still not legal in India. Neither under the personal laws, nor under the Special Marriage Act, nor under the Foreigners Marriage Act as well. And that is why in various states, petitions have been filed asking for legalizing same-sex marriages. Now what Supreme Court has done, Supreme Court has transferred to itself all the pleas, all the petitions related to same-sex marriage. And in all likelihood, the Supreme Court will uphold a right to marry for same-sex couples as well. But we'll have to wait and watch out for this newspaper article, watch out for this news item when the final verdict is given by the court. That's number 1. Number 2, there is a dispute as to who is the real Shiv Sena. Because Shiv Sena got split, the political party, one faction led by Shri Uddhav Thackeray and the other faction led by the current Chief Minister of Maharashtra, Shri Eknath Shinde. Now who controls the real Shiv Sena? Who will have the control over the election symbol That plea will be heard, that case will be heard by the Supreme Court on February 14. So watch out for that news as well. And third, August 2018, a constitution bench of the Supreme Court, it said that the advice of the Delhi Chief Minister and Council of Ministers is binding on the Lieutenant Governor, except in cases related to law and order, land and police. Because in Delhi, law and order, land and police, these are the subjects which are with the central government, not with the Delhi government, not with the Delhi Legislative Assembly. But who controls, who has the administrative control over the bureaucracy? Who has the control over the postings and the transfers of the bureaucrats? On this, there is a dispute, and this dispute is being heard by the Supreme Court. Watch out for that newspaper story. Watch out once the Supreme Court will give its final order as to who controls, who has the administrative control over the bureaucrats, their posting and administrative control. Chief Justice of India, Justice Chanda, has made some scathing arguments, observations in this case, but we'll have to wait and watch as to which way the Supreme Court will finally rule. So these are the three key topics to watch out for. Keep an eye as and when the Supreme Court gives a final order. We'll have to have an elaborate discussion on these three issues as well. That is it from us tonight. Thank you so much for staying with us. If you have liked this new weekly initiative, then press the like button, drop in your comments after the stream is over, subscribe to our channel if you haven't yet, and share the links of these classes with your friends and fellow aspirants. Hope to see you soon again next Saturday, 8 p.m. with another fascinating discussion on this beautiful subject known as Indian polity. Thank you, stay safe, good night.